we'd had some trial runs and all the audio was working. Something had changed in the settings, so I really appreciate your patience.
Thank you. So I'm going to kick it off. Belated welcome and thank you for those people who have joined us. I know Chief Chook of the Henhouse, Moira Weir, has joined us. My name's Lisa Chesser. I'm one of the Henhouse board members that's been working with the Working Women's Centre, and we've got Nikki from the Working Women's Centre today to go through workers' entitlements and your obligations potentially as a female employer or a small business owner, and how to make sure you don't get innocently involved in some practices that harm women and your businesses that you might be running. So Nikki's going to take us through a presentation. We're going to have some slides that she's going to share. Today is being recorded and will go up on the Chook's webpage, the Facebook page, for people to review afterwards if they can't join us today. And then we'll have a few questions and answers. So if you've got questions during the presentations, you'd like to put them in the chat feed, we would love to be able to talk about those after Nikki's presentation. So over to you, Nikki.
Excellent. Well, thank you so much, Lisa. And so like Lisa said, my name's Nikki. I'm one of the industrial officers here at the Working Women's Centre. And I'm just going to share my screen with you because I have prepared a presentation. So here it is. Thank you very much. So this is Employment Law 101 for small business. So we've put this trainings webinar package together, especially for Chook's SA, in consultation with Lisa, who suggested there may be some particular areas that might be of interest. Before I kick off, of course, I just want to acknowledge that the land we meet on, or that I am delivering this webinar from today, and I think Lisa is too, is the traditional lands of the Kaurna people, and that we respect their spiritual relationship with their country. And we also acknowledge the Kaurna people as the custodians of the Adelaide region, and that their cultural and heritage beliefs are still as important to the living Kaurna people today. So I'm from the Working Women's Centre, and we've been operating since 1979. The Working Women's Centre is a non-government organisation, and we provide free and confidential information, advice and representation to women and to vulnerable workers. But we also provide these free advice sessions for small business in relation to federal workplace laws. So these will be the ones that any of the chooks running a business would be applicable. So I'll just go through a little overview of the session. And of course, Lisa, I just wanted to invite you to ask any questions as we go along. If there's anything that comes up that you think might be of interest to the broader Chooks community, I'm happy to answer those as we go, and of course, answer the questions at the end. So what we're going to go through today is looking at the different types of workers and looking at employment itself. We'll look at where you can find fair pay and entitlements and where to find the correct pay rates and conditions. We'll briefly touch on the national employment standards. We'll look at superannuation, what records a business needs to keep in relation to their employees. And we'll look at a fair disciplinary process and how you might go about ending employment fairly. So let's get started. So there are a variety of different types of workers. Well, of course, we commonly know that employees are workers, but increasingly we're seeing lots of people are engaged as contractors or subcontractors, also known as independent contractors. And it's really important to know the difference between the two, because there are different rights and responsibilities that are assigned to the different types of relationships. So we'll look at these a little bit more closely in order that you can ensure that you engage someone in the correct way and don't end up in hot water. So what is an employee? Let's look at that first. So employees will typically work for a wage or a salary. They'll have tax withheld from their pay. And they'll usually work from a particular place of business. So it can be an establishment, an office or a shop. These days it can also be from home, of course. And employers generally exercise a fair amount of control over an employee. So where they perform the work, when they perform the work, what tasks they're required to do, and how much pay, while it can be negotiated, is often set by the employer. So employers are considered to be a part of the employee's business. Within employment, there are, of course, different types of employees. Might be a full-time worker who will usually have the hours of work set, usually 38, but it can be changed in an individual employment contract. A part-time worker would be anyone who works less than 38 hours per week. They should have their minimum part-time hours agreed at the commencement of employment, and that should be in writing. But the full-time and part-time workers should receive paid annual leave, paid sick leave, and paid public holidays. But of course, if you're a casual worker, or you engage casual workers, they don't have a guaranteed minimum number of hours, so they're able to fluctuate. They don't receive the paid annual leave or sick leave, and they don't get paid for public holidays. So that all sounds pretty bleak for casual workers, but of course the casual workers are entitled to a higher rate of pay. So it will vary depending on the particular industry and whether or not an award applies, but usually the casual loading, which is what they get for not being paid all those other entitlements like leave and paid public holidays, they get this casual loading, which is usually 25% on top of their base rate. They're also entitled to 2 days of unpaid carers leave and 5 days of unpaid domestic and family violence leave. So that very, very quickly just considers an employee. The other type of worker I mentioned, which a business operator may engage, is an independent contractor. So it's a starkly different relationship of engagement to an employee. So a contractor, in essence, should be someone who's running their own business. And I'll go through now some of the typical criteria of someone running their own business as an independent contractor. So they'd usually have an ABN, they send invoices to the client for the work that they've done. They use their own equipment. So for example, if someone was an HR consultant working as an independent contractor, they would have their own computer, their own phone, their own intellectual property, and they would bill for the work that they do with an invoice using their ABN. They would likely work for the completion of a job or assignment and not be paid by the hour like an employee. They can also negotiate or set the price for their work, and they work their own hours to complete the job. So it's quite a different scenario to employment. It's unlawful for an employer to engage someone as an independent contractor if the true nature of the relationship is actually that of an employee. So we often see businesses, and particularly small businesses who don't have a dedicated human resource department, fall into the trap of thinking that they can hire someone as an independent contractor as a cost-saving measure, because an independent contracting arrangement won't require the payment of the minimum wages or superannuation or leave. But it's really important to understand that it is illegal for an employer to do that. And even if you didn't do it deliberately, but you thought that it was okay, it still can be unlawful and illegal to engage someone in that way. And the courts will look at what the real relationship is, not the label that the parties put on the arrangement. And just touching back on independent contractors, if, for example, a business did engage a worker as an independent contractor and not an employee, and didn't pay the employee all of those associated minimum entitlements, they can end up in a situation where there's been an underpayment of wages, and they may be required to pay those back and also liable to other penalties under the law. So let's have a look now at how much an employee should be paid. So most minimum rates for employees in Australia are set by the modern awards, or the awards. So they're the legal documents that outline minimum pay rates and conditions of employment and they apply to workers and businesses depending on the industry that they work in. So, for example, there is a hair and beauty award, there is a fast food award, there is a building and construction award. So, depending on the type of work performed by the employer. And I've provided a link there to the Fair Work Ombudsman's website, and they have a very, very useful tool called the Pay and Conditions tool, where you can essentially go in and look at the awards and find out what award would apply and what the minimum rate is. So what is the minimum wage in Australia? So there is a national Australian minimum wage, which currently is $20.33 per hour, or $772.60 for a full-time worker. So no worker in Australia over the age of 18 should be paid less than that. We've got a little disclaimer there that if a worker is under 18 or a trainee or apprentice, the wage can be lower than that. But otherwise, workers should never be paid less than $20.33 if they're an adult. And that's the case even if they did agree to that rate. You cannot agree or contract below those minimum entitlements. So a lot of workers actually receive more than $20.33 per hour. Now, of course, that's the full-time or part-time rate, and there's casual loadings. Other entitlements might also apply on top of that, on top of the employee's base rate. So there may be penalty rates for working outside of normal hours, so unsociable hours like on the weekends or on public holidays. And also some modern awards have higher rates than the federal minimum. So it's really important to see if an award applies to the particular type of work the business does and therefore the employee undertakes, and to make sure you're abiding by those conditions in that award. So the National Employment Standards, so the Fair Work Act sets out about 11 minimum entitlements that all employees in Australia are entitled to. So they're set out there, and I won't go through each one individually. I've also provided a link there where you can get more information from the Fair Work Ombudsman's website. But these conditions, like the maximum weekly hours, annual leave and parental leave, these are all entitlements that every employee should get. There is a slight caveat, that is not all of these 11 standards apply to casual workers. So, for example, all of those leave entitlements, parental leave, carers leave, community leave, that they're all unpaid leave for casual workers. So it's really, really important that employers keep records and provide their workers with pay slips. So record keeping is required under the Fair Work regulations. The records of an employee are required to be kept for 7 years, and there's required to be kept in quite specific detail. So it should include employees' details of who they are and their name, address, and how to contact them, their pay rates, the hours that they work, any leave that they've accrued or taken, plus their superannuation contributions. So it's important, very, very important to keep those. There are penalties available, that can be, employers can be penalised for not keeping those records. And it's important also to ensure that you provide pay slips to any employees. Again, the Fair Work Act says that employers must not only give employees a pay slip, but they need to do it within 1 working day of paying them. So not only is it good record keeping, but employers can face, like I said, those financial penalties for not keeping the records or for failing to provide pay slips. So really, really important to keep good records. I'll now turn to superannuation. So the minimum superannuation that each employee is eligible to be paid is 10% of their ordinary time earnings. But keep in mind, this is scheduled to progressively increase over the next few years. And by 2025, it will be up to 12%. So that's called the super guarantee, and that is the minimum that you can pay. Some workplaces may pay a higher percentage, but that's usually because they would have, for example, an enterprise bargaining agreement where they've agreed to pay more, but currently 10% is the minimum. And so the 10% is paid on ordinary time earnings. And so ordinary time earnings means the ordinary hours of work for each employee. So the things that ordinary time hours includes are over award payments. So if you choose to pay a worker more than the minimum, any commissions or shift loading, annual leave and allowances. However, it doesn't cover overtime. So here we're looking at the ordinary hours, so the normal hours that they work unless specified differently. If you can't determine the normal hours of work, the actual hours the employee works are their ordinary hours of work. And again, overtime payments are not included. So a big warning here, which is that if by mistake an employee is paid less than the minimum entitlements, and that includes superannuation, they can make claims to have that money back paid to them. So an employee could calculate what they were paid if it was below the minimum, and then calculate what they should have been paid under the minimum entitlement, for example, under the award. And then they can claim the balance between like the underpayment and what they should have been paid. So they can make claims in the Employment Tribunal or the Federal Circuit Court to claim that money back. Now, it's also possible that employees can make additional claims when they pursue an underpayment for a penalty. And so there are additional penalties available under the Fair Work Act that employees can claim, which essentially is to penalise the employer for breaking the law. So it's really, really important to get the pay rates right, because as employers, you may really expose yourself to liability for getting it wrong. So we'll now have a look at a fair investigation and disciplinary process. And so what to do if you've got an employee who is not performing or there is conduct concerns. So let's say, for example, you had an employee who you were concerned, like working in a shop, and you were concerned or had a report in that they'd stolen $50 from the cash register. So the first thing you would need to do is undertake an independent investigation. So you'd need to give the employee a letter of allegations that sets out exactly what it is that you suspect they have done. So you need to be specific about the dates and times, and ask them to respond to those allegations. So you need to put it to them. Also, you need to, if there were any witnesses, someone that was working with them that day, interview that witness as part of the investigation process to get their perspective. It would then be appropriate to hold a meeting to go through the allegations and invite the employee's response to those allegations. So the meeting should be held during work hours, and an employee should be offered a support person. They should be really given a genuine chance to tell their side of the story. So it's their opportunity to let you as the employer know what they say happened. Once the investigation process is over and you've had the meeting and determined, it's then time to look at, like, well, what is the outcome of this disciplinary process? So potential outcomes can involve, if it's related to performance, more training or a performance improvement plan, which we'll look at, or if, for example, it was the example that I gave with the money missing from the till, might be appropriate to issue a formal warning, or in that instance, it may be appropriate to dismiss the employee because stealing from your employer is pretty serious and breaks down that trust and confidence in the relationship. So within a fair disciplinary process, if it's in relation to performance improvement, having a performance improvement plan is okay, but there needs to be a clear pathway to improvement with a measurable outcome, and a reasonable timeframe and a time limit. So a fair performance improvement plan should not be indefinite. There should be, for example, a 3-month period with clear and measurable outcomes. There should be support and training along the way, and you genuinely need to assist that employee to come up to that level of performance that you're expecting. If after you've been through a disciplinary process for performance or misconduct, and it is your decision to terminate the employee's employment, you can, of course, dismiss an employee, but you have to have a valid reason that relates to their capacity or conduct. So there can be, if the employee is guilty of serious misconduct, so that's something really serious, like the examples I have there on the slide, like theft or fraud or assault, or if they're sexually harassing another staff member, that is grounds for instant dismissal without notice. Another reason that might be considered a valid reason might be ongoing underperformance, where you've attempted to go through a performance improvement plan and it hasn't worked and they're still not able to perform up to the standard that's required. That could be a valid reason for dismissal. You would need to, of course, warn them that if their performance doesn't improve, that termination is a potential outcome. And then, of course, if there is a redundancy, so there's a restructure and perhaps the job that the person was doing is no longer required, that would be a redundancy. And again, that's a valid reason to terminate someone's employment. So you need to follow that fair process and also keep a record of the process, any of the correspondence that's been sent with the allegations, letters asking them to come to a meeting, all of that should be kept, because that's information and evidence that you would use to protect yourself if an unfair dismissal application was lodged. So again, employees should know the reason for their dismissal and be given an opportunity to respond to that before their employment is terminated. With small businesses, there are some special rules. So small businesses are characterised as a business with less than 15 employees. So that means a small business doesn't have to pay redundancy in most cases. An employee can only make an unfair dismissal claim against a small business if they've worked there for 12 months. So there's a mandatory minimum engagement period of 12 months if a worker works for a small business they must have worked there for 12 months to be eligible. So it essentially means that as a small business, all of your employees will have a 12-month probation period because they can be terminated within that period. And the worker would be prevented from making an unfair dismissal claim. They would not be eligible. And small businesses are similarly exempt from unfair dismissal claims if they can show that they followed the Small Business Fair Dismissal Code. Again, I've provided a link there to the Fair Work Ombudsman website, which has some useful information about the Small Business Dismissal Code, but you'll need to follow that and demonstrate to the Fair Work Commission that you have followed the process in there to effect dismissal. So finally, it's unlawful to dismiss an employee for several protected grounds. So for example, it's unlawful to dismiss an employee for a discriminatory reason. So I've provided some examples there of protected characteristics. So you can't sack someone because they're pregnant or because they're gay. You similarly can't terminate someone's employment for being absent from work because of an illness or an injury. And you can't end someone's employment for engaging in lawful industrial activity. So that might be protected industrial action during enterprise bargaining. And you similarly cannot dismiss an employee lawfully because they've exercised a workplace right. So that might be a workplace right to join, for example, a trade union or to make a complaint of bullying and harassment. So all of those reasons are not legitimate lawful reasons to terminate an employee's employment, and they would not have to fulfill that minimum mandatory period of employment to make a claim against their employer. So just to sort of summarise the dismissal provisions I went through there, you can fairly and lawfully dismiss an employee. It will be fair and lawful if it's for that valid reason related to performance or misconduct, and there was a fair process followed, and provided that it's not for one of those protected or discriminatory reasons. Like I flagged before, employees can challenge the termination of their employment in the Fair Work Commission, and they may be successful if you have not followed those processes. So that comes to the end of my formal presentation, and I'll open up now to any questions that anybody might have.
Okay, I've got a question.
Okay, great.
About the superannuation. Remitting it in superannuation in your ATO obligations for employees. A lot of people use Xero and software packages like that to do their BAS and simple things, but these aren't necessarily synced to your BAS statements. Remittance dates are different. And how can people find out when those dates are, when the step up with the changes in percentage of super occur over the next few years?
Well, the changes to the percentage of the superannuation guarantee, so increasing from 10% to 12.5%, those dates are available on the Australian Tax Office's website. So they are scheduled updates, so they could be diarised. But look, in terms of the business activity statements and the other query, I think that's sort of crossing over into an area outside my area of expertise, and maybe looking more closely at taxation and reporting laws, and might be better put to an accountant. I wish I could answer it, Lisa, but I can't.
Fine. Oh, now the other thing I'd like to mention is the Hen House has actually got a partnership for a women-led business in super that's called SuperFizz, and we get some money to help us achieve our mission of ending the gender gap investment if people decide to switch their super to SuperFizz. So that's a partnership like we have with the Working Women's Centre to empower women to have control over their workers' rights, but also over their superannuation. So the link for SuperFizz is in the chat feed. Are there other questions around this? I'm curious about the sham contractor, because I think a lot of people get caught of that when they're students, potentially.
So that the students are engaged as an independent contractor, or engaging someone as an independent contractor?
I'm thinking of people who food delivery programs like that have been media profiled.
Certainly, we get lots and lots of inquiries from workers who have had their employment characterised as an independent contracting relationship. But when they come to us and we go through exactly what they're doing, and we assess against those criteria that I went through before, how much control they have. Are they really running their own business? Were they able to negotiate their pay? Do they wear a uniform? Do they have their own tools? What level of control do they have in their ability to perform their hours? Or when and how they do the work. So an assessment is made considering all of that indicia. And certainly we get a lot of students, young people that are in that situation, and it is we make claims for them and on behalf of them to claw back some of those entitlements that they may have lost out on, or to seek a penalty against an employer because they have in some cases deliberately attempted to disguise the employment as an independent contracting relationship to get out of paying their legal entitlements. So sometimes it's deliberate, and sometimes it is it's a lack of knowledge about the way in which a business should engage an employee.
Yeah, so Maura's just saying on the thread that a lot of parents with kids who are teenagers working for small businesses and local food delivery, that's a concern that people aren't raising that. And the thing about having workers' rights and the power of this relationship is if you raise questions, you're the troublemaker. I've encountered that in a couple of workplaces, and they manage you out as a consequence discreetly, or they just drop your hours and you. So what in that situation, if you're politely questioning the status hierarchy, what ways can the Working Women's Centre support women and small business owners to be just and fair, but also to answer these questions without being threatened?
Yeah. Well, firstly, there are protections under the Fair Work Act called the general protections that protect a worker from being treated adversely. So for being, for example, dismissed for exercising their workplace right, and that could be a right to be paid their minimum entitlements. They could raise that they're in a sham contracting relationship, and they are able, if they're terminated for doing that, there are claims that they can make to challenge the legality of the employer's behaviour in order if that did happen, because the examples you've given are unlawful. I think for workers, it's really important to be a part of your trade union so that you can get advice, like continued advice on your working relationship. But certainly the Working Women's Centre can help non-union members with any queries about a particular engagement, and to ask our advice and our view on whether or not we think it's a lawful arrangement, and to help with some strategies of how they might go about trying to remedy the situation if it is indeed an unlawful arrangement.
Thanks, Nikki. Last one, probably.
Sure.
one we've got is pregnancy and pregnancy breaks, and making sure that women's biological and needs and health needs other than they're dealt with, and not, you don't compound and potentially create a workers' compensation claim or tension or ill health on both sides.
Yeah, certainly. So, workers, pregnant women are entitled to paid, parental leave. So, under the Fair Work legislation, they're entitled to 12 months of unpaid leave. There's now also the federal government scheme where you're entitled to be paid for 18 weeks at the federal minimum wage. So that's a claim that isn't made directly through the employer; it's made through Centrelink. But an employer also has additional obligations in relation to a worker that takes a period of parental leave. So there's a guarantee under the Fair Work Act that when a worker returns from a period of paid parental leave, that they are returned to their pre-parental leave position. So it's a guarantee that the employer will hold that position for the worker that's on maternity leave and allow them to return to it. And there are other protections as well in the discrimination laws around treating someone unfavourably because of a pregnancy. So to terminate someone's employment or to demote them to lesser duties or lesser pay. So there's a variety of different protections available. So yeah, businesses should be across the parental leave provisions in the Act, and also having a look at what constitutes discrimination in order that, yeah, you avoid treating someone in an unlawful way.
That's great. Thank you so much for sharing the information today. I hope it's been useful to Hen House board members and cooperative members, but also to the Chooks Wisdom Well that we have on Facebook that goes beyond South Australia and goes internationally and around Australia now, with over 3,000 women having access to this presentation. Thank you so much for everyone who's joined us today, and particularly thank you to Nikki for the presentation and for the leadership that the Working Women's Centre continues to provide in South Australia. Please reach out to them, send us comments on the Facebook page once we post this as a video, as a resource. And thank you for joining us today, and have a lovely Friday.
Thanks, Lisa.
Bye, everyone.